not all rental violations are created equal. Hi, my name is Rob Wells. I'm the Landlord Warrior on TikTok and YouTube. Please feel free to like, share, and subscribe to our videos. Now, I was just talking with a landlord about a couple of lease violations that their tenant was engaged in. And, one of them was the classic, pet, at the property, a dog in this case, in violation of the lease, and also allegations of drug dealing and so forth. And I was talking with this landlord, and he seemed like he was more focused on the dog issue, and for good reason, because in California, a lot of insurance companies are canceling policies for having various hazards, such as certain breeds of dogs, and so forth like that. And I was talking to this landlord. He was telling me about the dogs, and then he kind of mentions, "Hey, I guess the neighbors are complaining about drugs," and kind of like brushes us off for a minute. And I go, wait, hold on a sec, real quick, because the drug deal is significant, and let me explain why. What's rolling in a landlord attorney's mind, or should be rolling in their mind, is the type of violation that a landlord's calling about, okay? Because there are like two classes of like violations. They're curable violations, which are a majority of lease issues or rental issues. Hey, keeping your place clean, not having pets or dogs or unauthorized residents in against the lease. Those are usually what the law deems as curable violations. One of the prerequisites you're going to have is you're going to have a written rental agreement that has terms that specify what a tenant can and can't do. Like you can't have unauthorized occupants reside at the property. Only people listed here can live here. No pets, etc. Okay. And then you have like a set of violations, which would be kind of I would classify them as incurable, or they're very significant. Such as a grave nuisance, criminal activity, and so forth. The Code of Civil Procedure actually kind of separates these items, actually. And the reason why it's significant is generally with a curable violation, tenant has to be given an opportunity to fix the violation or cease violating the rental agreement. You have to give them a 3-day notice to perform, telling tenant, hey, listen, you're violating paragraph A of the lease. You got to stop. If not, we can terminate the tenancy. Versus incurable violations, a landlord legally doesn't have to give a notice to tell the tenant to stop, or else the tenancy will be terminated. It will be terminated, basically. And that's under Code of Civil Procedures, sections 1161, subdivision 3. And the incurable ones are Code of Civil Procedure, section 1161, subdivision 4. So that's where it makes a big difference. Also, having drug activity in and of itself is deemed a nuisance in California. So that is pretty significant. And landlords can use those incurable notices to terminate tenancies immediately if that's happening. Obviously, a lot of facts go into these things, and you got to consult with landlords counsel to figure out which violations you might have or how to address it, because every situation is going to be different. But that's what's going on in your landlord's attorney's mind here. So if you have any questions, or if you have a situation like this, feel free to reach out. Put your questions in the comments. I'll try to answer them to the best of my ability. Until next time, folks, I'll talk to you then. Thanks.